Step out of the vehicle now. This car isn't yours.
Excuse me? Yes, it is. Why?
Don't lie to me. People like you don't just drive something like this around here.
I have the registration.
Save it.
My name.
Save it. I asked who it really belongs to.
Told you.
Hands up. If you don't step out right now, I'm detaining you for suspicion.
What you just heard started as a routine traffic stop, but it was anything but routine. A sheriff approached a black woman in her 50s, immediately assumed the luxury car couldn't belong to her, and escalated to threats of detention without clear cause. What he didn't realize was that the woman behind the wheel was a sitting Texas judge, and that his assumptions were about to trigger a $35 million lawsuit. That single moment of bias would not only expose his conduct, but put his badge, his department, and the system itself under scrutiny. Her name is Judge Alana Brooks, 54 years old. She has served on the Texas District Court bench for over 18 years, after spending more than a decade as a prosecutor and civil rights attorney. A graduate of the University of Texas School of Law, she built her reputation handling complex felony cases, and later presided over more than 3,000 criminal and civil proceedings, with a record consistently upheld on appeal. Known for her judicial discipline and courtroom integrity, Judge Brooks has received multiple state bar recognitions for ethics and public service, earning the trust of attorneys, law enforcement officials, and the community she serves. The officer was Deputy Mark Ellison, 42 years old, a 14-year veteran of the Redfield County Sheriff's Office. He had spent most of his career assigned to patrol, with prior internal notes describing him as proactive and assertive in enforcement situations. But public records show that over the past 6 years, Ellison had accumulated 9 formal citizen complaints, 5 of them alleging racial profiling during traffic stops. Internal Affairs investigated each case. 7 were dismissed for insufficient evidence, 2 resulted in written reprimands that never advanced beyond his personnel file. None led to suspension. None affected his patrol status. Despite the pattern, Ellison remained in active field duty. Supervisors repeatedly classified the complaints as unsubstantiated, citing lack of video clarity or conflicting testimony. In practice, the department closed the cases internally, and no disciplinary record followed him outside the agency. The system had reviewed him before and kept him on the street. Judge Alana Brooks was driving north on Westfield Avenue, a quiet residential corridor lined with brick homes and trimmed hedges, less than 10 minutes from the courthouse where she had worked for nearly 2 decades. It was mid-afternoon, clear visibility, light traffic. She had just left a judicial conference downtown and was heading home. Her vehicle, a late model black Mercedes sedan, was properly registered and displayed current tags. She stopped at a 4-way intersection near Pinecrest Drive. A marked Redfield County Sheriff's Patrol unit pulled in behind her. There was no visible traffic violation. The patrol vehicle followed her for approximately 2 blocks. Then the emergency lights activated. Judge Brooks slowed immediately and pulled over along the curb near a public park entrance. She placed the vehicle in park. Both hands remained visible on the steering wheel. Deputy Mark Ellison exited his cruiser. Bodycam footage shows him adjusting his belt as he approached the driver's side. His pace was fast, his posture rigid. No greeting. He leaned toward the partially lowered window. "Step out of the vehicle now. This car isn't yours." Judge Brooks turned her head slightly, visibly confused but composed. "Excuse me. Yes, it is. Why would you? Don't lie to me. People like you don't just drive something like this around here." The assumption was immediate. No request for license. No explanation of probable cause. The tone was accusatory from the first sentence. The implication was clear. A black woman in a luxury vehicle must be illegitimate. "I have the registration. It's in my name," she replied, keeping both hands raised slightly off the wheel. Deputy Ellison stepped closer. The camera angle shifts as he leans inward. "Save it. I asked who it really belongs to." Traffic passed slowly behind them. A pedestrian on the sidewalk turned to watch. Judge Brooks reached slowly toward her purse on the passenger seat. "Tell me before you move," Ellison snapped, his hand briefly hovering near his holster. "I'm getting my ID," she said, calm. "Controlled. You're already acting nervous," he responded. She froze momentarily. "I'm not nervous. I'm confused. Why was I pulled over?" "You fit a description," he said. "What description?" "Step out of the car." No description was provided. No Bolo alert was cited. No matching suspect details were articulated. The interaction escalated without evidence. The only visible factor distinguishing Judge Brooks in that moment was her race. She opened the door slowly and stepped onto the sidewalk. She was wearing a navy blazer and low heels. Her hands were visible. Ellison positioned himself between her and the vehicle. "Turn around." "For what reason?" she asked. "Don't argue with me." He guided her toward the rear of the car. His grip on her upper arm was firm but controlled. She did not resist. "This is my vehicle," she stated again. "You can run the plates. They'll be run," he replied sharply. The patrol radio crackled in the background. Ellison called in the license plate number. As dispatch processed the registration, he continued questioning. "Where do you work?" "That's not relevant," she answered. "It is if you're driving something you can't afford." The statement was not investigative. It was declarative. It carried an assumption rooted in bias that her presence in that vehicle required justification. "I am a district court judge," she said evenly. There was a pause. Ellison's posture shifted slightly. "License and registration," he demanded again. She handed over the documents. The registration matched her name. The address on her driver's license matched the registration. Dispatch confirmed. Vehicle registered to Alana Brooks. No warrants, no alerts. Ellison remained silent for several seconds. He examined the documents longer than necessary. "You should understand how this looks," he said. "How what looks?" she asked. "High-end vehicle. Area we've had thefts in. There have been no theft bulletins matching this vehicle," she responded. He did not answer that directly. Instead, he returned to the patrol car with her documents. She stood on the sidewalk alone, hands at her sides. Neighbors watched from across the street. A black woman in professional attire, detained in public, questioned about whether she could afford her own car. No violation cited, no description given, only suspicion. After several minutes, Ellison returned. "You're free to go," he said flatly. "For what reason was I stopped?" she asked again. "Routine check." It was not routine. There was no traffic infraction, no broken taillight, no erratic driving. The initial claim was ownership suspicion. The follow-up explanation changed. She re-entered her vehicle, closed the door, adjusted the mirror with steady hands. Ellison walked back to his cruiser without apology. The sequence was clear. She was stopped without cause, accused without evidence, questioned about her ability to own her own property, escalated to the threat of detention. The trigger was not behavior. It was not conduct. It was the sight of a black woman in a luxury car. That is what unfolded on Westfield Avenue. The turning point came when Deputy Ellison returned to the rear of the vehicle instead of ending the stop. Dispatch had already confirmed that the Mercedes was legally registered to Judge Alana Brooks. No stolen vehicle alert, no outstanding warrants, no active investigation tied to the plate. The objective facts were clear, but Ellison did not disengage. He approached her again as she stood beside the car. "Place your hands behind your back," he said. "For what?" she asked. Failure to comply and obstruction. There had been no obstruction. She had complied with every command. Hands visible. Identification provided. No resistance. A woman walking her dog stopped on the sidewalk. "Officer, what is she doing?" the woman asked. "She hasn't done anything, ma'am. Stay back," Ellison responded sharply. The neighbor did not move. "She lives around here. I've seen her." "This is ridiculous." Ellison ignored her. He stepped closer to Judge Brooks and tightened his grip on her wrists. In that moment, the reality shifted. This was no longer confusion. It was no longer a misunderstanding. It was a decision. Judge Brooks later described the psychological clarity of that second. The realization was not emotional. It was clinical. She understood she was not being evaluated as a driver. She was being evaluated as a black woman in a car the officer had decided she did not belong in. She said calmly, "You stopped me because you believe this car cannot belong to me." Ellison did not deny it. "You fit the pattern," he replied. "What pattern?" she asked. "High-value vehicle, suspicious behavior." There had been no suspicious behavior. The pattern was unspoken but visible. Another bystander began recording with a phone. "This is profiling," the bystander said loudly. "You're profiling her." Ellison turned briefly toward the camera. "You don't know what you're talking about." The bystander responded, "We do. This isn't the first time." That statement referenced what had already been documented in internal complaints. Deputy Ellison had accumulated 9 formal citizen complaints in 6 years. 5 alleged racial profiling during traffic stops, 7 were dismissed for insufficient evidence, 2 resulted in minor reprimands, none led to suspension, none removed him from patrol. In several prior complaints, black drivers reported being told their vehicles didn't match their profile or that they were in the wrong neighborhood. One complainant wrote that Ellison looks for crime where there isn't any. Another stated he assumes wrongdoing first and asks questions later. Those patterns were on record. They were known to supervisors. They were not acted upon. Now the behavior was unfolding again, in public, in daylight. Judge Brooks stood with her hands restrained behind her back. "I have complied with every instruction," she said. "State your legal basis." "You're being detained pending further investigation." Ellison replied. "What investigation?" she asked. He did not specify. The neighbor stepped closer. "Despite the warning, you already ran the plate," she said. "It's her car." Ellison's voice grew louder. "Mom, back up or you will be cited for interference." The authority in his tone was designed to silence witnesses. It did not address the substance of the objection. Judge Brooks felt the weight of the handcuffs tighten slightly as she shifted her stance. She later described the internal calculation happening in real time. Stay calm. Document everything. Do not escalate. Survive the encounter. This is the psychological dimension of racial profiling. It is not confusion. It is not misunderstanding. It is recognition. The recognition that evidence no longer matters, that compliance no longer protects you, that the suspicion is not tied to behavior, but to identity. "I am a sitting district court judge," she stated clearly. There was a brief silence. Ellison responded, "That doesn't change the stop. It should have changed the stop only in one way. It should have ended it. Credentials were verifiable. Identification was valid. Registration matched. There was no legal threshold for continued detention. Instead, the detention continued." The bystander spoke again. "You're embarrassing her for nothing." Another voice from across the street added, "This happens too often." Ellison kept his focus forward. He did not acknowledge the statements. He did not release the restraints. Public humiliation is not accidental in these encounters. It is structural. It reinforces authority. It communicates who is presumed suspect and who is presumed legitimate. Judge Brooks stood on a public sidewalk, handcuffed beside her own vehicle, after being told people like her do not drive cars like that. There was no traffic violation, no matching suspect description, no stolen vehicle report. The only constant variable was race. The injustice was no longer subtle. It was visible to neighbors, audible on recording devices, and documented on body camera footage. Yet the authority figure proceeded as if nothing was wrong. That is the moment when a routine stop becomes evidence. The institutional turning point began less than 24 hours later. Bodycam footage had already circulated beyond the sheriff's office. A bystander's recording, clearer and wider in angle, showed the full exchange, including the statement, "People like you don't just drive something like this around here." That line became central. The Redfield County Sheriff's Office command staff convened an internal review meeting. The following morning, present were the chief deputy, the internal affairs supervisor, and the county's legal counsel. The footage was played in full. No one disputed what was said. No one disputed that the license plate had cleared before the detention escalated. The chief deputy paused the video at the moment Judge Brooks was handcuffed. "Why is she being detained after confirmation of ownership?" he asked. Internal affairs had no answer. She fit a pattern. Someone said quietly, "That is not a legal standard." County counsel replied, "At the same time, Judge Brooks' chambers had formally notified the state Judicial Administrative Office. Her credentials were verified immediately, not that they were needed, but they removed any remaining ambiguity. She had been treated not as a driver under suspicion of a specific offense, but as a black woman presumed illegitimate in possession of her own property." Within hours, the Texas Judicial Council's legal liaison contacted the sheriff directly. "Was the stop based on probable cause?" the liaison asked. "We're reviewing that," the sheriff responded. "Review it quickly. This involves a sitting district judge. The issue was no longer a street encounter. It was liability." County risk management began calculating exposure, false detention, civil rights violation, racial discrimination, public humiliation, video evidence, witnesses, a documented complaint history. Deputy Ellison's personnel file was pulled. 9 prior complaints, 5 alleging racial profiling, 7 dismissed as unsubstantiated, to written reprimands, all internal, none escalated. County counsel turned pages deliberately. This pattern was visible, she said. You had noticed. That word, notice, changed the tone in the room. If a pattern exists and no corrective action follows, liability extends beyond the individual officer. It reaches supervision. It reaches policy. The sheriff watched the footage again. The statement about people like you played a second time. That language is indefensible, counsel said. The sheriff nodded. Put him on administrative leave. The decision was immediate. Deputy Ellison was removed from patrol pending investigation. His badge and service weapon were surrendered. Standard procedure, but urgent. When notified, he responded defensively. I was doing my job, he said. You escalated after confirmation, the chief deputy replied. She was acting suspicious. How? There was no documented answer. Internal Affairs opened a formal misconduct inquiry. The charge, unlawful detention and conduct inconsistent with department policy. The department's public information officer prepared a statement. It acknowledged the stop. It confirmed review. It avoided admission of wrongdoing behind closed doors. The language was more direct. If this goes to federal court, county counsel said, we're exposed under civil rights statute. The footage shows escalation without legal basis. It shows bias. It also shows something broader. Institutional tolerance. The prior complaints, dismissed repeatedly for lack of evidence, now look different when placed alongside video. The question shifted from what Ellison did that afternoon to what supervisors failed to do. In the years before, policy manuals were retrieved, bias training records were reviewed, annual evaluations were examined. There were no documented remedial interventions after the profiling complaints. Did anyone ever flag this pattern? The sheriff asked. Silence. This was no longer about one traffic stop. It was about systemic failure to act on warning signs. Meanwhile, Judge Brooks retained counsel. A formal preservation letter was sent to the county demanding that all records, dispatch logs, bodycam footage, and complaint histories be secured. The legal basis for a civil claim was clear: unlawful detention, violation of constitutional rights, racial discrimination under color of law. The sheriff requested a private meeting with Judge Brooks. She declined. This is not a misunderstanding, she stated through counsel. This is conduct. The department faced a narrowing set of options: deny and litigate, or acknowledge and reform. The institutional turning point was not emotional. It was structural. Evidence had surfaced. Patterns had been documented. Supervisory failure had been identified. And for the first time, the department could no longer describe Deputy Ellison's behavior as isolated. It had record. It had notice. It had video. Corrective action was no longer discretionary. It was legally necessary. Within weeks, Judge Alana Brooks filed a federal civil rights lawsuit against Deputy Mark Ellison at Redfield County. The complaint alleged unlawful detention, violation of 4th and 14th Amendment protections, and racial discrimination under color of law. It cited the bodycam footage, the bystander recordings, and Ellison's documented history of profiling complaints. The filing was direct. She was stopped without probable cause, accused without evidence, detained after verification of ownership, and publicly humiliated because she was a black woman driving a vehicle the officer decided could not belong to her. During discovery, internal records became central evidence. 9 prior complaints, 5 alleging racial profiling. Supervisors had marked 7 unsubstantiated and issued to minor reprimands. No suspension, no remedial training, no pattern review, no policy intervention. County counsel attempted to argue that each incident had been individually assessed. Judge Brooks' attorney responded in court. When the same allegation appears repeatedly and the department does nothing, that is not individual review, that is institutional tolerance. Depositions revealed that no early warning system had flagged Ellison's repeated profiling allegations. There was no tracking mechanism requiring command staff to reassess officers. With multiple bias complaints, supervisors admitted under oath that they had not reviewed the aggregate pattern. The legal exposure widened. A federal magistrate denied the county's motion to dismiss. The complaint plausibly alleges a pattern of discriminatory enforcement. The court wrote, settlement. Negotiations began shortly afterward. The final settlement totaled $35 million. The breakdown was public: $18 million allocated for civil rights violations, and unlawful detention, $7 million designated for reputational harm and emotional distress. $5 million for punitive damages against the county, $5 million earmarked for mandatory departmental reform and independent monitoring over a 5-year period. Deputy Ellison was terminated following the internal affairs investigation. The termination letter cited conduct unbecoming, violation of detention policy, and failure to adhere to constitutional standards. When notified, Ellison reportedly stated, "I treated her like anyone else." The evidence contradicted that claim. The footage showed escalation after verification. The language showed bias. The prior complaints showed pattern. He lost his badge. He lost his pension eligibility tied to active service status. The district attorney declined to pursue criminal charges, but his law enforcement career ended. Redfield County entered into a consent agreement requiring structural reforms. An independent oversight monitor was appointed. All traffic stops were now subject to demographic data collection and quarterly bias review. A formal early intervention system was implemented, flagging officers after 3 substantiated or repeated bias-related complaints. Mandatory anti-bias and constitutional policing training was expanded and made subject to external audit. Supervisors were required to certify review of cumulative complaint histories. During annual evaluations, the sheriff publicly acknowledged policy failure. In hindsight, patterns should have been addressed earlier, he stated during a press conference. Judge Brooks responded separately, "This was not hindsight. It was visible. It was reported. It was ignored." The case became a reference point in statewide law enforcement training seminars. The footage was used as an example of how unchecked assumptions escalate into constitutional violations. The underlying issue remained clear. She was not stopped because of a traffic violation. She was not detained because of evidence. She was questioned about whether she could afford her own property. She was handcuffed after proof of ownership. The suspicion did not arise from conduct. It arose from race. The financial cost was measurable, $35 million in public funds. The institutional cost was reputational, federal scrutiny, oversight, policy restructuring. The personal cost to Deputy Ellison was career-ending. The message was equally measurable. Patterns matter. Documentation matters. Bias, when ignored, becomes liability. The lawsuit did not erase what happened on Westfield Avenue. It did establish consequence. And consequence, in this case, was public, documented, and permanent. This story is meant to generate awareness. It proves that a single traffic stop can expose something much larger. How assumptions rooted in race can escalate into detention, humiliation, and constitutional violations, even when the facts are clear. In 2025, Black Americans were nearly 3 times more likely to be killed by police than white Americans. And 77% of Black adults say they are treated less fairly by police than white people. Those numbers do not exist in isolation. They reflect patterns of suspicion without cause, escalation without evidence, and accountability that often comes only after public pressure. Ask yourself, how many similar stops never make headlines? How many complaints are dismissed before a camera forces attention? How many patterns are labeled unsubstantiated until liability becomes unavoidable? And how many people do not have the platform, credentials, or resources to fight back? Do you know any organizations that work to protect the rights of Black people in America? Legal support groups, community safety initiatives, civil rights coalitions? Share them in the comments. Let's support those working for justice and safety for all. What are your thoughts on this case? Do you believe systemic reforms go far enough, or is deeper change needed? Leave your perspective below. Start the conversation. Awareness matters. Accountability matters. Thank you for watching. See you in the next video.